All right, well, Josh, thanks for having me, and thanks for having this panel. Really thrilled to be here with you guys. So today we're going to be talking about foreign third-party litigation funding and its potential national security implications. We're thrilled to have you join us here at George Mason University's Mason Square for what promises to be an exciting and impassioned deep dive, or I'm going to make it impassioned if nobody else is going to do it. Deep dive into one of the most important and complex issues facing both our legal system today and national security. Third-party litigation funding, or TPLF, has quickly evolved into a multi-billion-dollar industry, drawing attention from courts, Congress, and increasingly from those of us in the national security community. In particular, there have been extensive discussions in recent years about the threat from foreign nation states, particularly China, and the threat it might pose to the U.S. legal system and the use of third-party litigation funding in our system. Today, we'll dive deep into the issues of foreign litigation finance, talking about how it works in practice, how foreign nation states engage in such financing, whether through investment vehicles or state-owned or state-influenced companies, and how foreign nation states might use American litigation tools to achieve larger national goals. We'll also talk about whether the role of foreign countries, including American adversaries in American courts, rises to the level of being an actual national security threat. And we'll discuss its potential impact on our strategic industries and the American intellectual property system writ large. As part of this conversation, we'll also talk about potential policy solutions in play to address these concerns, including existing mechanisms used by federal and state courts, proposed legislation, and potential disclosure rules. To help us navigate this critical discussion, we've gathered an outstanding group of experts from diverse sectors, each with a unique perspective on how foreign litigation is playing out in the U.S. legal system. I've got a big and distinguished panel here, so give me a few minutes to introduce each of our panelists. Immediately to my right is Vishal Amin. Vishal is the head of intellectual property policy at the Intel Corporation. He leads global intellectual property policy and advocacy for Intel, focusing on balanced innovation, IP protection, and open market principles. Previously, Vishal served as the U.S. IP Enforcement Coordinator, also known as the IP Czar, at the White House, where he shaped key IP enforcement policies. Prior to the White House, Vishal served as senior counsel to the House Judiciary Committee, where he led the drafting of bills including the Defend Trade Secrets Act of 2016 and the American Invents Act. Vishal holds a bachelor's degree in neuroscience from Johns Hopkins and a law degree from WashU at St. Louis. Connor Murphy is the Senior Vice President for Litigation Insurance at Lockton. With over a decade of experience in the insurance sector, Connor specializes in managing complex litigation risks for clients in both the public and private sectors. At Lockton, Connor advises on insurance solutions to mitigate financial exposure tied to high-stakes lawsuits. Prior to joining Lockton, Connor serves as director at Burford Capital, a premier provider of litigation finance and legal risk management. Connor also held senior roles at BDO Global Forensics, Capstone Advisory Group, and Navigant, and holds bachelor's degrees in accounting and finance from the University of Notre Dame and a JD from St. John's. Immediately to Connor's right is Kristen Osenga. She's the Associate Dean for Academic Affairs and the Austin E. Owen Research Scholar and Professor of Law at the University of Richmond Law School. Go Spiders. A leading scholar on intellectual property and administrative law, Dean Osenga's research focuses on patent law, innovation policy, and how third-party litigation funding affects innovation ecosystems. Prior to joining the University of Richmond Law faculty in 2006, Dean Osenga practiced at Finnegan Henderson and clerked for Judge Richard Lynn of the U.S. Court of Appeals for the Federal Circuit. Dean Osenga has also taught classes at Chicago Kent College of Law and been a visiting professor at Emory and at William & Mary. Dean Osenga holds a BS degree in biomedical engineering from the University of Iowa, an MS degree in electrical engineering from Southern Illinois, Carbondale, and a JD from the University of Illinois College of Law, where she graduated magna cum laude. Courtney Paul Taylor. Paul Taylor is a visiting fellow at the National Security Institute, which I run here at the law school, and a distinguished legal expert with extensive experience in common law, civil rights, and government oversight. Paul's legal career spans over 2 decades, even though he doesn't look it, and includes extensive service on Capitol Hill, including as senior Republican counsel at the House Committee on Oversight and Government Reform, where he led efforts related to civil rights and civil liberties, and as counsel and chief counsel of the House Subcommittee on the Constitution, Civil Rights, and Civil Liberties. In these roles, Paul played a pivotal role in advancing numerous bills into law, impacting both domestic and federal legal frameworks across a wide range of areas. Paul holds a BA in political science from Yale, where he graduated summa cum laude, a JD from Harvard, where he graduated cum laude. He's also an elected member of the American Law Institute, being the first congressional staff member to earn this honor in the ALI's 100-year legal history. And last but certainly not least, Courtney Quish is the managing director of Fortress Investment Group, where she oversees investments in IP and commercial litigation assets. With over a decade and a half of experience, Courtney has a proven track record in designing IP development programs, managing mergers, monetizing IP assets. Her leadership has been instrumental in driving IP strategy and growth and for numerous organizations. Prior to Fortress, Courtney held senior roles at Rovi Corporation, now TiVo, where she developed strategies for growth through strategic partnerships, corporate acquisitions, and patent transactions. She also was a member at Mintz Levin, where she counseled clients and protecting and leveraging IP assets through licensing, litigation, strategic transactions, and began her career at Pepper Hamilton, where she worked on IP litigation and strategic counseling. Courtney holds a BA in psychology, Spanish, and mathematics from Middlebury College and a JD from the University of Michigan. In addition to her legal work, Courtney once co-founded a company called Pocket Door. And so we are off to the races. So let's just jump right in, folks. Vishal, I'm going to start with you since you're immediately to my right. Talk to us about third-party litigation funding. How's it grown in prominence in recent years? What are the ways that foreign entities are getting involved with it? And from your perspective, what are the key ways that foreign-funded litigation finance is impacting industries related to national security, like technology, which you're in now? And talk about the specific concerns that folks have about intellectual property.
All right. Thanks, Jamil, and thanks to everyone for being here so late in the afternoon. I know you've got a lot of snacks outside that you're missing to hear this riveting conversation.
I sort of berated people into coming, saying that I was the moderator, and if they didn't come in, I'd be embarrassed. So.
Well, once I heard Jamil say that, I figured we'd have all the seats filled. I mean, but
I try.
No, thank you again. Thank you for having me here. Litigation finance, I mean, particularly from sort of the national security context, it's not relatively like new industry, sort of in terms of kind of my familiarity with it, and what we've seen in the intellectual property context, obviously, a lot more litigation, over the past maybe 5-6 years in the IP space, supposedly backed by litigation funders, et cetera, and some of those types of industries. I've seen various statistics, including, some 30% of, all cases are potentially litigation funded, et cetera, and all of that sort of that deal. On the national security side, I think it's...
Sorry, 30% of cases generally are financed by litigation funders?
I've seen those statistics. Okay. I think it's kind of one of those things where you don't know what you don't know, basically.
Right.
And so it's all kind of estimates, by economists, et cetera, on this type of thing. On the national security side, we kind of look at like some of these cases that are going into the courts, and we look at the types of cases that are going through, and like there's when you see these cases, you kind of look at them from the context of, all right, what industries are they primarily targeting? Who are the actors involved? Who's funding it? Who benefits from it? You start thinking through, and you kind of put that old government national security hat on and start thinking through, like, all right, if you potentially have foreign competitors, if you have nation-state actors, if you have other sort of nefarious kind of foreign elements, et cetera, that are potentially funding it, what would be the sort of the reasons behind that? And so if you take, for example, the hypothetical of the energy industry. You talk about, sort of imagine right now you had, Russian natural gas producers.
Yeah.
Decided, all right, we want to take a bite out of the U.S., sort of energy industry. What would you do then at that point? Probably a host of sort of, clandestine activities, corporate espionage, et cetera, they could do.
Blow up a pipeline.
Blow up a pipeline. There's, lots of those types of activities that could happen. But another, activity could potentially be suing these folks. And so if you're the, Russian entity, you go after independent energy producers in the United States, folks that, potentially can't stay in business if they are in heavy litigation, and you start going after them one by one.
Yeah. And
so, at that point, the question comes down to, is that something that the courts should have any sort of awareness over, basically?
And so Vishal, is there evidence, though? Is there any? Do we have proof that foreign nation states are actually financing this kind of litigation?
So, what we have is what we've seen in some of the courts have uncovered. I think Judge Connolly in Delaware uncovered, Chinese backed entities, funding, litigation. There was, I believe there was reporting done where there were, folks connected to Russian oligarchs that were funding certain cases. And so, look, these are all like specific individual examples.
Yeah.
Ultimately, we just don't know what we don't know.
Yeah. Well, so Courtney, Fortress is one of the leading financiers of litigation in the U.S. You're part of Fortress, in fact, is one of the lead. You.
No, actually, that's not correct. But I'm happy to. There are two parts of Fortress.
Okay.
There is a legal assets group, of which I am not a member.
Okay.
They focus entirely on litigation funding in one way, shape, or form. It's largely in law firm loans, not in litigation funding specific loans. Our team, it's less than 5% of our investment is litigation funding.
Got it.
We can talk about the definition of litigation funding because that seems to be its own slippery slope.
Yeah.
But I'd love a chance to just respond to Vishal right off the
No,
bat
please,
here.
jump in. I mean, talk about the scale of this issue.
Let me start at the beginning. I mean, patent litigation has almost decreased by 50% in the last 10 years. So I don't know if it, just to clarify, there has not been any increase in patent litigation due to funding. I mean, yes, there has been an increase in funding over the last 10 years. At the very same time, patent litigation has gone from, I think it was 6,500 to 3,600 cases. So you're not seeing an increase. I appreciate that there may be threats from China and others. I just, as my colleague, I'm going to steal his words, doesn't pass the straight face test. I'm sorry. It's not, you could bomb let's just use you could go after a pipeline or you could file a litigation that costs $10 to $20 million of a large entity. Like we could even have it be an Intel, today's market cap was $96 billion. Do we really think defense of that case is going to handicap large companies at all? I mean,
if you ask Google, I think Google would tell you it's a real problem, right?
Google would tell you it's not a problem at the filing. They tell you it's a problem because they're losing. And the reason they're losing is because they're good faith litigations. Now, let's get into sort of what's the purpose for it. I don't think it's harassment. I just don't. You're talking about pennies on the hundreds of dollars. It doesn't make a difference. Do competitors do that to competitors all the time? Absolutely. We saw Apple versus Samsung. We see chipset, fights all the time, and those are acceptable, right? So it seems like large parties are allowed to have fights with large parties, but really what third-party litigation funding is going to is supporting the little guy. And you're taking away all of the little guy's abilities to fight. I want to hit on the other one because we're going to get there, that someone would file these lawsuits to obtain trade secrets, confidential information, whether that be business information or technical information. That doesn't pass the straight face test either. I mean, there are protective orders in absolutely every intellectual property case, and those protective orders are negotiated between the plaintiff and the defendant. Information is very closely held and it's protected. It's sitting with outside counsel only. And finally, because I don't want to steal this whole show, let's talk about the examples. Russian oligarchs. I'm very familiar with the case. That was a laundering case, right? They weren't trying to steal secrets. They weren't trying to harass a defendant. They were laundering money. They were already breaking rules. Do I think that's a problem? Yeah. But do we have laws in place against that already? Absolutely. And the China, I think that's Purple Vine probably related. Yes, there was funding from a Chinese company called Purple Vine. I didn't hear anything about that being for ill purpose. Maybe it was, and I just missed that part of it, but I'm not sure there was any argument made that was made for harassing, foreign interference, confidential business information collection at all. It was just funded from a Chinese party.
Let me just ask you a follow-up question. Do you not think that foreign governments are funding litigation in U.S. courts for the purpose of achieving national goals? Do you think that's just not a real thing?
I haven't seen any evidence of it. I'd love to be educated differently, but I just haven't. I mean, there was a June hearing on the Hill when there were a whole bunch of experts, including Mr. Taylor here up there. No one gave an example of that. They gave an example of Cisco, which was a non-IP case. They called out VLSI, not a third-party funding case. I didn't hear of an example, so I would love to hear them. And by the way, I'm sure there's one out there, I'm sure. But is a single bad apple going to drive an entire hypothetical we don't know what we don't know? I mean, the risk here, and we'll talk about it more, because I know it's what you're about to say next, Jamil, is why not just share the information?
Yeah, let's
right?
find out, right?
But
let's find out.
Let me just be really clear. You get asked for full disclosure, and you shut down third-party litigation funding. And that's the real reason why we're having this conversation.
All right, so we'll come back to that. Professor Osenga, I want to draw you in an encounter. I know you got something to say here, too. So Dean, talk to us about whether this is a real problem, right? The litigation funding generally, but in particular, the foreign piece of it. There's a debate about whether this is a problem at all. Have you seen any evidence? What do you know about this? And talk to us about whether, if it is a potential issue, are there potential national security implications in play here or not, in your mind?
Okay. So I'm going to do what law professors do and not answer a single question that Jamil just asked me, because I'd much rather talk about what I feel like talking about.
But you can't filibuster. You can do it if you want, but don't filibuster.
Not filibustering.
All right.
But I also, for the law students in the room, and I know there's at least one because she transferred from Richmond to Mason.
What?
Right over there. Anyway, so. Sorry to call you out, Lily. So I want to kind of bring us back to first principles so that we can kind of level set, because I think Courtney said something super important, that what would happen if we just take away third-party litigation funding. So I want to start there. I'm going to focus on patents. That's my area of expertise, and I want to just remind everybody in the room who probably already knows this, that the only right that a patent actually gives you is the right to exclude. That's it. That is exactly the right you get from having a patent. And if you can't exclude an infringer from using your patent, the patent loses its value. And we heard from the first panel how important it is for you to have that right to exclude. That's what the entire first panel was about. eBay made it more difficult to get injunctive relief. And without the deterrence of injunctive relief, a lot of infringers engage in what John on the first panel called economic infringement. Other people call it efficient infringement. I call it predatory infringement because I think that's more accurate. But the idea is you fringe now, pay later. Don't worry, I'm getting to the third-party litigation funding part. By the time you get to that pay later point, the patent owner has to sue. Okay? The only way you can exercise this right to exclude, especially when we have predatory infringement, is you have to bring a lawsuit. Oftentimes, to obtain the necessary remedies, you're going to need to sue on multiple fronts. These patent battles are occurring in the PTAB and the ITC and the district courts and foreign courts all at the same time. This is very, very expensive. And as Lori mentioned on the first panel, what happens then is your deeper resource companies can tie up another company in knots for a very long time, and it comes a battle of attrition. And the well-resourced companies can outlast the small companies in particular, but even not the small companies who aren't as well-resourced. And so what happens with third-party litigation funding is it levels the playing field. It allows the little guy to exercise their patent rights in the same way that a big, well-funded company can exercise their patent rights. And that makes the patent system stronger. And so that's why it's super important. Patent owners can use this funding to afford these steep legal bills and stay in the game long enough to actually have their patents maintain some value. So to get to a few more of Jamil's actual questions, is there evidence of foreign interference in the IP system or in the American economy based on, we don't know what we don't know.
Right.
So no, there's no evidence. And so I think that's a concern. It's hard to say a lot about the scope and scale of it, but I think we have to think about the national security implications of having a very weak United States patent system. And that, I think, is actually a real problem. And so if we take away third-party litigation funding, what we've actually done is weakened the United States patent system, and that, I think, actually creates a national security problem. And I'll stop there.
Okay. So, Connor, I know you want to be drawn into this, and you've actually been a litigation funder. So, like Courtney, you've actually been in this business. Now you're on the insurance side of it. Talk to us about whether, well, we've heard it may or may not be an issue. We don't know, right? We've heard it is an issue. We suspect it's an issue. But Courtney says those aren't good citations, right? So, how do you see that? How do you see this? Is this a real problem? This foreign litigation funding question, and if it is or isn't, right? What should we be thinking about it?
Okay, so I mean, there are a number of things. If I start bleeding, it's because I'm biting my lip here, trying to not jump in too much here. So
by the way, I want to encourage like a little bit of a dialogue back and forth across the So let's not be law professors and talk at each other. Let's debate it. Let's fight it out.
I was at Burford Capital, which is the largest or one of the largest or one of the probably the best known litigation funder for 6 years. We invested in both law firms and single case litigations or patent campaigns or whatever the case might be, and all commercial. No individual, suing their doctor or any of that stuff. And it was all very much, large litigations, often international. I saw zero evidence of any foreign tinkering or blowing things up or whatever the case might be. Where you do see it is, and it's public, not the identity of, but there is $1 billion of sovereign wealth money invested in and through Burford Capital to enjoy the attractive returns that are litigation funding. Now, when we looked at cases and evaluated cases, and we looked at a lot of them and looked at a lot of them every year. 95.5% of those cases do not get funded by Burford Capital for a host of reasons, but many of which are just not meritorious enough to be invested. Maybe they're a good enough case to be taken under other financial arrangements, but it's very selective. So,
Because you're in the business to make money.
well, why throw money after a case that you're not going to see your money again? Now,
Right.
it does happen too. You do lose, but that's something to just kind of bear in mind. But I don't, I didn't see any evidence of that at my time.
And I'm going to ask a question that I think I know the answer to, but your investors at Burford, which is pretty reflective of many others, did they see case by case what you were doing
No.
before you did it?
No, of course
Did
not.
they have influence in how you were managing?
None.
Did they have access to information that the lawyers in the case received?
None. And then, so the other thing that came up is we talk about disclosure and whether that is, existential to the funding world. I tend to think it's not, but it also isn't details. What does disclosure mean? It could mean a host of things. And
Yeah.
we've seen pockets of local rules where you have to disclose that there's a third party of interest, but, not the terms or who
Right.
the funder is. So
Right.
that's a whole separate panel that we could have.
Well, so let's talk about this disclosure question, right? Because both Courtney and Dina Osenga have told us that we're not sure if there's a problem or how big the problem is, right? You say, well, I haven't seen any evidence that suggests, at least at Burford there is, but we know there's sovereign wealth money, right? But to Courtney's point, maybe the LPs don't control the litigation, they don't even see it ahead of time, they want their returns, they're happy with their returns, right? But what about the scenario where it's a single LP fund? We know those exist in the venture world, we know they exist in the litigation world, right? Isn't it possible that maybe not diversified funds like Burford or Fortress, right, but single LP funds could be financing litigation on behalf of a single sovereign wealth fund?
Possible.
Burford's
a publicly traded.
Right,
not an LP,
right.
I think that's possible, Jamil. I just think that, first, it certainly isn't the way we operate because we have many LPs. But I guess the question would still be, so what? I mean, I don't buy the harassment. They don't gain access to information in the litigation. So is it just that you don't want them playing? And that's okay if that's your answer, but let's just be honest.
In a single LP world, though, right, whether they get access to information or not, it's a whole different story.
No,
right?
no, because there is a protective order. The only people that see that information.
I mean, come on.
No,
Protective orders,
No way. You call Wilmer Hale, call Irel Manila, call these top-notch law firms. Ask them if they take those seriously.
Yeah.
Ask them if they're going to get disbarred over sharing information to some funder. Absolutely not. And if you think it's law firms doing that, well, first of all, shame on our judicial system, and we have a much bigger
we have a lot of
problem.
law firms representing a lot of shady clients in the American judicial system. Now, maybe everybody gets a good lawyer, right? But let's be real, right? I mean, we have all sorts of American law firms representing all sorts of shady Chinese companies in American courts.
I guess so. I mean,
one might just look at TikTok.
To me, you're a solution in search of a problem. You're saying, wow, now I'm going to say all the U.S. lawyers can't be trusted with their own ethical duties. And so now, because I can't trust U.S. barred lawyers to comply with their own ethical duties, I have to put in place disclosure rules?
Well, so Paul, let me pull you into this session. You testified before the Judiciary Committee recently on these topics. Talk to us about how you see the problem and whether this is a real thing or not.
Okay, so from the legal ethics standpoint, there's one case that I think illustrates a lot of these issues. The Cisco case that you mentioned earlier. So
A non-IP case, just to be clear.
non-IP case, but it illustrates a lot of these issues. Keep in mind that there are only a few judges that even have disclosure orders out of over 800 federal judges. So the stories and the examples we're giving are drawn from that incredibly small subset of judges, which indicates to me that the problem it could be much more extensive than we're leading on to believe, because there's a lot of examples from just a few districts. But let me give this Cisco example, just so that people can get a concrete image in their mind about what might be going on. So Cisco is a food distributor, and it sues some of its suppliers, antitrust case. Burford, I believe, was the funder. And it turns out that after a while, Cisco, the litigation had gone on for a long time, they grew weary of the litigation. They wanted to settle the case. These were people they were going to have to deal with, these food suppliers, into the future. I guess they didn't want to have bad blood. They wanted to settle the case. So they agreed to settle at a certain number. Burford, and this all came out in the litigation, said, you can't do that. Your funding contract with us gives us the authority to decide what is an adequate settlement amount. Now, if you read anything about legal ethics, which hardly anybody does anymore, you'll read books by Anthony Cronman, former dean of Yale, who points out that a lawyer is really supposed to put themselves in the shoes of the client and try to understand as best they can the circumstance of the client and conduct the case in accordance with the client's wishes. Of course, lawyers have to make money. They got to cover their costs in the case. But what happens when the funder, with a fiduciary duty to return profits to its investors, what happens when that fiduciary duty trumps the duty of loyalty that the lawyer has to the client? So in this case, Cisco wanted to settle. Burford said, no, it's too low. They weren't allowed to escape the litigation as the client wanted to do, Cisco. Now, it turned out, subsequently, the magistrate judge found more information, which was that Burford, apparently, and this is what the magistrate judge wrote, was trying to up the settlement value of that particular case, not only to maximize its profits in that case, but also because they were seeking to use that settlement number as a benchmark for going to investors for other future cases and say, look what we got in this one case. Invest with us, we'll get you more. So not only was the interests of Cisco, the client, neglected, but the insistence on a higher settlement value was linked to other potential future cases in order to further an investment proposal for cases in the future. So the other problem is that Jeffrey Hazard, he's another legal ethicist, he's written the main treatise on legal ethics. He says the problem is this: our civil litigation system is built on the idea that Jones v. Smith. Jones has a unified position. Smith has a unified position. In order to resolve conflicts in our civil litigation system, both sides of the V have to have some sort of unified position. But as the Cisco case demonstrates, when the funders are controlling the litigation, then there are disputes on that side of the V. So you cannot have unanimity of position on both sides of the V in order to facilitate the resolution of civil disputes. So I think that's a very big deal. Now, there was a article that came out, where was it? It just came out yesterday in Bloomberg Law. And this is the quote from the article. It says, in litigation funding, law firms that take money from Fortress, a litigation funder, have their bank accounts tracked weekly and their cases monitored closely. One litigation funder said he passed on taking money from Fortress because, quote, they choke you to death, unquote. Jack Newmark, a Fortress managing partner and co-CIO, said, this is his quote, we see where funds go. If you do something you're not supposed to do, we're going to be upset, unquote. And this is the reporter's language now. One consistent principle is that if Fortress agrees to provide capital to a funder, it will be hands-on. Now, it's interesting when you look at the history of a lot of these, the early cases where organizations helped litigants bring cases. The NAACP. It's a case in the 1960s, went up to the Supreme Court. The state of Virginia, unfortunately, had this racist law that was trying to prevent the NAACP from coordinating with the plaintiffs. Goes up to the Supreme Court. The Supreme Court fortunately strikes down that Virginia law. But they say this, the case was NAACP versus Button. The Supreme Court approved the NAACP's involvement because its arrangement with the civil rights plaintiffs, in that arrangement, quote, this is the Supreme Court, no monetary stakes are involved, and so there is no danger that the attorney will desert or subvert the paramount interests of his client to enrich himself or an outside sponsor. And the aims and interests of the NAACP have not been shown to conflict with those of its members and non-member litigants. The key is to what extent the funders are controlling the case for a pure profit motive that is independent of the client's interests. And if I could, just jump to the foreign policy aspect of this. Now, it's true, there aren't any clear smoking guns that we've discovered yet in these few jurisdictions that require disclosure. But I just listened last week to a discussion with this, the ranking House Democrat on the House Select Committee on the Chinese Communist Party. His name is, I'm probably going to butcher his name.
Raj Krishnamurthy.
There you go. Ranking Democrat on that committee. And if you will just indulge me, and then I will stop talking, a short quote from
Just
him.
so you know, Courtney, I'm coming to you next. I see Connor shaking
Wait,
his head too. I know you got to get in here. I know you got to get in here. But Courtney's first name taking advance. So I got to give her a shot first.
So the
But you're
ranking
coming in too.
Democrat on the Select Committee says, this is his quote, "I just want to point out to you why a Chinese company is unlike any other entity that we have seen, at least in my experience, competing, I put in air quotes, in the United States in providing goods and services. There are two reasons," he says. "One is under the 1993 company law in the People's Republic of China, every single company has a CCP cell embedded at the top management of the corporation to basically run the company, to inform the management of how to make sure that whatever it does complies with what the CCP wants. The second aspect, which is more recent, is a series of laws that have come forth basically in the form of the national security law, for instance, and others, where these companies must be the instrument of the CCP with regard to foreign intelligence collection." I mean, that kind of blew me away. And again, this is not some crazy Republican conspiracy theorist. This is the top Democrat on that committee saying you have to realize that there's, in every company, and its organizing principles and charters, and the employed there is someone whose job is to make sure the company furthers the interests of the Chinese Communist Party. That's no joke. I mean, you think about it. I mean, they mentioned at this same forum that 80% of the cranes that take cargo off ships are Chinese made. And they're embedded within them is the capacity for the Chinese Communist Party to literally remote control them. It's a big deal. It's interesting to think about. Now, third-party funding, if you add a Chinese company or other foreign companies' involvement with third-party funding, you add that on top of control of the litigation, and there is a recipe for disaster. And I think more and more judges are becoming concerned about this. In fact, I mean, I talked to one judge, and he just said, you know, I don't know what's going on behind these curtains. Judge Connolly in Delaware came up with his first disclosure order because he was having sidebars with lawyers, and he was asking them questions about how to solve this. And some of the lawyers were like, well, I can't get back to you right now. I mean, I got to go consult somebody. He's like, who? I mean, isn't everybody who's relevant here in the courtroom? That's what got him to issue this first disclosure order. Now, if a foreign company is involved with this and it's third-party litigation financing and it's intending to further the interests of the Communist Party, who knows what they can do? We've all been involved with litigation. There are contractors, there are subcontractors, there are people who deal with sensitive information. And I think in the Purple Vine case, there were actually former in-house lawyers for the tech company that was being sued who had taken privileged and confidential information, given it to Purple Vine, which Purple Vine used in the decision to fund the case. So, anyway.
Yeah, all right, little Courtney.
Yeah, I mean, we're conflating two issues here, right? I mean, the quote has nothing to do with litigation. It has nothing to do with litigation funding. I'm going to repeat what I said.
Which quote? Which quote?
The China discussion at the end. I'm going to go in reverse order, okay?
All right, yeah.
So, but I'm going to circle back to what I said at the beginning. I don't doubt that there is a threat from China and others. I just don't believe it's in third-party litigation funding. And I want to highlight something here. Many of the biggest proponents and supporters of transparency acts are public and private large U.S. corporations who have huge presences in China, including people on this panel. Factories in China, an innovation hub in China. If I'm worried about China stealing my stuff, I probably shouldn't pouring money into factories and fabs in China. I think there's a more significant risk of trade secrets getting stolen in China because, to your point, Paul, there are going to be Chinese employees there who will report to the CCP than litigation funding. Now, if we flip to the first argument, it is true that Fortress watches its money very carefully. That quote doesn't say anything about a specific litigation. In fact, the issue is we have law firms misusing our money and our loans. It's not a China issue. It is a law firm misappropriation issue.
But we're supposed to trust all those lawyers and the protective orders, but not misappropriate your money.
Well, hey,
we'll trust
no,
them,
we
trust them
watch
on
it.
one side, but not the
Oh,
other.
I think those are totally different issues. But
just-
hold on,
but
hold on.
just to come back, just real quick. So you took a shot, right?
I'm surprised. I just can't believe you're really doubting the protective order compliance. I'm really surprised by that.
Well, I think to Paul's point that there's plenty of reason to believe that there are a lot of people in a piece of litigation that are bound by a protective order notionally, but that aren't the American lawyer, the partners of the firm, right?
But the only
there's plenty of
people-
third-party
the only-
contractors. There's plenty of people who are engaged in looking at materials.
It's experts whose whole professional livelihood is based on.
Not just the experts, the contractors who do doc review.
No. Are you kidding? They don't have access. You mean the contractors from the law firms?
Yeah, the law firms contractors who are looking at doing doc review. Thousands and thousands of staff attorneys plowing through.
I don't know if there's thousands of anybody, but.
I mean, when I worked at a litigation shop, let me just tell you, we employed hundreds upon hundreds of contract attorneys to look at litigation documents before any associate or partner saw them.
I guess that hypothetical that I've never seen identified in real life could be a problem, and I'm game to have a conversation on how we solve that.
Yeah.
I'm not sure that has anything to do with litigation funding. Regardless of who funds it, you're gonna have a trade secret problem. You're gonna have a trade secret access and leakage problem if people are violating their ethical duties. It really has nothing to do with who's funding it in the back.
Right, no, but the problem, right, is if it's a financier whose goal is to not win the litigation or doesn't even care about the success of litigation, simply brings it to tie the company up in knots, right?
So then okay, let me just follow up. See, they hire a law firm. They tell the law firm to hire certain contractors. They get the contractors to violate their ethical duties and send the money back to the financiers.
how many times have we seen China plant people in American corporations to steal IP? It happens with reckless abandon across the
No, I
country
agree. I guess
over
I'm-
dozens of years. They do it.
But that's
we
not
know they
tying
do
to
it.
the financing.
No, but we know
You're
they do it.
still not
So,
tying to the
so
financing.
you think it's less likely they're going to go hire a scientist, spend years to get them into Dow Chemical or wherever it might be, but they won't hire a law firm to sue somebody?
No, I think if I were them, I'd say, I just saw in Docket Navigator that somebody sued anybody, Intel,
I brought that suit. I got that suit brought.
Some random person, I don't care who, somebody they care about. And they'd say, now I'm just gonna sneak my guy in. Why do you need a litigation funder for that?
You start the lawsuit. Yeah, good.
So,
Paul.
I mean, don't take my word for it. Last year, have anyone heard of the Foreign Agents Registration Act?
FARA, for sure.
FARA.
Yeah.
There's a part of the Department of Justice, and there's a unit that heads that, and you're supposed to disclose things if you're representing foreign governments. The head of that unit last year gave a speech in which he mentioned the risks of, quote, undisclosed and undiscoverable third-party litigation funding in U.S. litigation, including the risks of foreign entities doing business in the U.S., seeking to create a competitive advantage as compared to their U.S. competitors by tying up U.S. companies in lengthy and expensive court cases, and the risks that foreign funders of U.S. litigation may gain access to proprietary and sensitive commercial information through litigation discovery. That's not me. That's the head of the Justice Department's FARA division.
Yeah, but there's no information behind it. That's
Well, so that's maybe that's the point.
There's
So
nothing
Courtney, why not
to.
disclose? So why not require disclosure of forget what Americans are financing litigation, right? Why not require disclosure of countries of concern, right? Russia, China, North Korea, Iran, right? Where they're funding litigation in U.S. courts, them or their corporate entities or high net worth individuals from those countries. Why is that a problem? If it's not a big issue, the quantity will be zero. If they're not in your funds, they're not in Burford, no big deal. All good, right?
I think if you define who they are, if they're on an OFAC list, great, define them. Identify them. I'm game because our investors aren't allowed to be on that list, right?
Right. No, but what about just any China? We know that China evades OFAC all the time by creating shell entities. That's never going to work. So how about if you just said any Chinese LP? Why is that a problem? You don't have any Chinese LPs.
I don't think that's
what's the big deal?
I think if you said it's a Chinese LP, but that's not what people are looking for.
But let's say
right
they
now.
did. Let's say that was the deal on the table.
Okay, it's a
Chinese, Russian, Iranian, North Korean LPs.
I probably don't care because
What
I
about
just
Burford?
don't think
Connor?
that's the issue.
I agree. I don't think that's the issue, and I don't think that's I think again, a solution looking for a problem.
No, but that wouldn't be a problem. You don't think for Burford to
but
disclose?
Can I flip it for those that are supporters of the transparency? Would that be sufficient? I mean, there are two, would that be
Well, I mean,
sufficient?
to my mind, no, you have to understand.
Well, set aside the control. I
You have to
appreciate your
understand the control.
I appreciate your control issue, your ethical
Your
control
control
thing,
issues.
but that's different than the foreign. They're totally different issues. So,
I mean,
on
as a
the-
starting point,
They're not
Paul, would you
within
want to know if Chinese companies or entities controlled by Chinese entities or have significant influence, would you be supportive of that as a starting point for disclosure?
no, not as a starting point.
Well, but let me-
as the answer.
No, but I mean, Paul?
Well, I mean, I think there needs to be disclosure both as to the parties and to the terms of the agreement.
Okay.
Now, the legislation that's out there now, there's a Darrell Issa bill, and there's a Mike Johnson and Senator Kennedy bill. The Issa bill requires disclosure of the names and the terms of the agreement, and the Johnson bill requires the disclosure of foreign entity involvement, but also bans any foreign entity or foreign sovereign wealth fund from being involved in the case. But the key is both of those pieces of legislation make disclosure the default, but they allow the court to, if they find reasons to not disclose based on their understanding of the case and the legal ethical issues involved. Remember, courts are supposed to oversee the officers of the court that are the lawyers. So
Yeah.
the courts have a role here. But both bills actually allow the judges, at their discretion, to either allow the disclosure, not allow it, or anything in between, which I think is appropriate, because this would be
yeah.
the court making its own decision on the matter.
So Dino Senga, I'm coming to you, Connor, in a second. Dino Senga, you and Courtney both made the point that that disclosure would shut down litigation finance. And we heard your explanation about why you're concerned about shutting down litigation finance, the little guy. I do think it's funny, Courtney, to your point about companies that build in China. I share your view on that, right, by the way. But it's kind of funny to hear a $9.9 billion fund or $6.6 billion fund, defending the little guy, right? I mean, like, let's be real. I mean,
Well,
come on.
I'm not. It doesn't matter how big I am. It's who are we funding? That's the little guy.
You're funding little guy like Cisco? That's the little guy?
Cisco wasn't me.
No, I know,
first of all.
but like.
I can introduce you to the inventor after inventor that
Yeah,
were
I got-
single
I got a whole-
inventors.
whole list of those as
So,
well.
all right, so
that's easy.
So Dino, just real quick though.
Yeah.
So one of the points you made, right, was that it would shut down litigation finance disclosure, right? Help us understand that. What is the concern? Because in most circumstances, right, election finance alike, we generally think disclosure is good. The American system generally builds on disclosure. What's the problem with disclosure? Why will that shut down litigation finance?
So I'm sure that Courtney and Connor could probably answer this question better, but I will give it a go and then.
We'll look at Connor shot right after you.
Okay.
And then Vishal, I'm going to drag you back into this fight at some point.
But I also want to say, I appreciate that the focus of this panel is on the national security and the foreign and stuff like that, but the ISA bill is not. The
Yeah.
ISA bill is absolutely not limited to foreign,
Right.
and it's being pushed by, at least we assume, the predatory infringers. Not the Chinese. The Chinese company are not pushing that.
I think there's different questions that are in play when it comes to non-foreign litigation. There's First Amendment questions.
I
Right.
get that. I just
Yeah.
want to say, I mean, if we're looking to that as this is the gold standard for disclosures, the ISA bill, this is great, look at this. It's like, wait a second, who's actually pushing that bill?
Right. But if
And
you
I
could
don't
take
think
that
it's
bill
China.
and limit it to foreign funders, then let's talk about that, right? But talk to me about why it would shut down litigation.
So a couple of things. If the predatory infringer or the Chinese company, but the predatory infringer knows who the funders are. First of all, they may have some insight into the litigation strategy. It's possible.
But I thought they didn't control the litigation strategy.
no.
Either they do or they don't. Which one
Not
is it?
control, but knowledge. Knowledge.
But
Knowing-
but hold on. How would knowing who's funding it give me insight to litigation strategy unless the funder controls litigation strategy?
Knowledge and control are not the same thing.
No,
Fair.
I don't want you to confuse. I mean, those agreements are nothing other than sort of this is when you're getting funded. So it's not laying out any litigation strategy. I think it gives insight into how much money they can spend, and then
Just by knowing the name of the funder?
No. She's talking about the agreement.
Oh, you're talking about the
She's
agreement.
talking about
The
terms.
agreement. Oh, the terms.
agreement.
I see. Okay.
The
I'm sorry.
terms,
I got you.
yeah.
Yeah. Okay.
The
I'm tracking.
terms
Yeah, keep
will
going.
lay out
Yeah,
a lot
yeah.
of information
Sure.
about strategy.
Sure. Okay. Understood.
And y'all said terms. You didn't just say
No,
names.
you're right. You're right. Funding.
Okay. And then the second thing is if you know who the funders are, you might be able to harass them. And that's problematic, I think. And that might discourage funders from participating
But
in
don't
the
we
system.
generally? But let me ask you this: don't we generally think that if you're if you're in the court system, right? When it's a typical, A versus B case, right? We know who's in the litigation. Then in theory, you could go harass them. We don't seem to have a problem with that. We don't allow people to come into American courts and hide their names when they sue in civil court. So why should we allow funders to hide their names when they sue in civil court? Like they might, a defendant, a plaintiff might get harassed anyways. Why should we protect financiers?
It's not relevant, and it's been deemed to be not relevant time and time.
No, but that's the debate. That's the policy question. Is it relevant?
But
that's the question we're debating.
And disclosed or not, you can often discern whether or not there's funding behind somebody. When you're on the defense side and you're throwing everything you can at them, and this plaintiff, who you think doesn't have any money, is meeting you step by step. You can probably read between the lines.
Right. So then wouldn't you want to know if it's a foreign corporation who's behind it? That's exactly the point. Right?
I know. I get the point. Foreign company. I mean, again, to your point, I understand the nature of the panel. I think, and if I can just go back to the Cisco.
Yeah, please. You did want to. I did say I'd give you a shot at that one.
There is an argument to be made that disclosure of the Cisco arrangement was actually good for litigation funding and Burford's business and maybe Fortress's business.
Tell us about that.
It showed that major corporations are using litigation funding to the tune of 9 figures.
Yeah.
And that deal.
So it's not the little guy necessarily all the time.
And that deal, Paul, was not had precious little to do with the price-fixing defendants in the protein cases. It had to do with Cisco not wanting to settle the case. They wanted to monetize their claim. They wanted to accelerate their fees in that case, or their expected award, which they did to the tune of $140 million. And then they breached the agreement, which is why we got to where we did. They breached the agreement by assigning away the collateral that was the $140 million that Burford gave them. I would encourage everybody in this room to Google Cisco and Burford. It's a fascinating case, but Burford didn't race to the courthouse steps to sue Cisco. They worked out a deal with them that then said, okay, we're then going to have to have some control over this litigation because you've assigned away a lot of this collateral, and you could potentially, Cisco wanted to settle for less than what they were into Burford for, which is how that all came to be. So I think in the big picture, the war that started 20 years ago was, can you do litigation funding? Is it legal? And I think that war has largely been won. It's as you put in the material, it's a multi-billion-dollar business worldwide. I think the battles that have been fought along the way are to do with disclosure, and I feel like that's largely been lost or being lost, and I think that's generally okay. I don't think we need to get into the terms of the deal. I think that's gone way too far. And even the identity of the funder, I think I'm okay with personally. But like I said, in the Cisco case, to see it get out in the public that this corporation did this deal is quite telling.
Well, Vishal, let me ask you this: since you've been sort of out of the fray for a little bit, putting aside any existing litigations going on now or the like, would Intel or companies like Intel, maybe you don't want to speak for Intel, it's fine. Would companies like Intel want to know if there were foreigners, and at least as a starting point, and forget whether, you're never going to give away all your rights to go do whatever else you want, but as a starting point to know whether there are foreign funders of litigation against you?
So, it's been a fascinating discussion, kind of, hearing everybody talk about kind of, the foreign funding doesn't really matter, domestic funding, whatever it might be. I think, just kind of pulling the panel back to kind of like the focus here, when we talk about, national security. In the national security world, it's not so much, it's not the rule, it's oftentimes the exception. And so I think that's really what we're trying to get at here.
Meaning what?
Meaning that the exception is that when you do have a nation-state actor or you have a nefarious foreign entity or foreign competitor or whatever it might be trying to engage in economic warfare against the United States.
Which we know happens.
In those instances, that's where, all of these various things, do occur. And so, look, we have folks in the panel. They know what they know or they don't know, and but there are a lot of folks out there engaged in this type of activity. And so the thing is, just like I don't know what everyone who their investors are and what they do and what they don't do, neither does anyone on this panel.
Yeah.
And so ultimately, what we're really trying to do here is like, look, we do know that there are, nation states, there are foreign, entities that engage in this type of, there's trade secret theft, it's cyber hacking, it's, all sorts of different things. Ultimately, it's just another way to get at, U.S. companies, at U.S., economic interests. And, in some respects, it's another tool in the toolkit for folks who would be, engaged in economic.
And so
cooperation.
we know that President Xi, right, has said that he wants to use the rule of law to his benefit, right? And so we know that is part of the Chinese sort of corporate national strategy to use the rule of law to their ends. And so I guess the question I would ask is, given that we know the adversary's strategy in this space, at least in the case of China, and given that we know that they are voraciously hungry for American intellectual property, why not simply disclose, at least put aside the agreements for a second, right? Put that on hold for a second. Why not disclose the identities of foreign financiers of litigation across the board in all litigation, IP or otherwise, in American courts? Why can't that be a simple starting point for the conversation?
So I'll give two answers.
Yeah.
One, that's not what the transparency people
Fair
want.
enough, but
They will never agree to that. I posed a question and I don't think I even got an answer. That's not sufficient.
But would you oppose that?
Here's my issue. I don't have an issue with your bad country list of 4,
Yeah.
right? But when you start saying any foreign investor, I mean, I have a couple issues with that. One is disclosure. These investors almost always own less than 1%. They are passive blind pool investors. They invest in sort of a high level mandate.
Mm-hmm.
They don't know what cases are being invested in. They don't know what law firms are being invested in.
They're looking for a return.
They're only looking for a
alpha.
return.
Yeah.
So so to identify them, I don't see how that matters here. They don't have any control. But in reaction to but so what? Just disclose them. It's harassment. And unlike
I'm not really that worried about the Chinese Communist Party being harassed. Like that's
I agree on China, but you just opened it up to all foreign investors. And I can tell you, even in our U.S. investors, when they are disclosed in litigation, they are harassed.
You mean they get stories about them in the paper?
No, I mean they'll get FOIA requests and state equivalent to FOIA requests. They are immediately put.
You mean like CalPERS, for example?
Yeah, that's a good example. CalPERS, UTIMCO,
Right.
Bam, there's a request. As soon as it's publicly disclosed.
Teachers Association.
Teachers associations.
Yeah.
Pension funds, hospital systems. And they don't want to do it.
What about that, Paul? That it'll drive financing out because now we're talking about foreign entities, so we're talking about the French Teachers Union, right, or whatever, or the ex-sovereign wealth fund, right?
But let's just think broader.
Yeah.
Insofar as an investor, foreign or otherwise, insofar as their funding agreement is controlling the case to a certain extent.
In U.S. courts.
In U.S. courts, the judge, of course, has to know who's in control of the case. He has to know what
that doesn't
who the
happen.
parties are.
Very-
You say it doesn't happen. There's so few jurisdictions.
But if it happens once, isn't that enough to justify the disclosure?
Now, I will grant you this.
Why?
If you do require disclosure, it may very well shut down cases. Whoa, here's an article from Law 360, and it says, quote, the Fortress Investment-Backed Company spent 3.5 years litigating patent infringement claims against Intel in Delaware, but elected to walk away as Chief Judge Connolly insisted on more disclosure into its ownership structure. VLSI agreed with Intel on Tuesday to a stipulated dismissal of its Delaware claims rather than submit to further inquiry from Connolly into VLSI.
But Courtney told you why. She doesn't want disclosure LPs.
Here's the problem. I know a lot more about VLSI than you do. They're not even litigation funded, Paul. They're not litigation funded.
But I'm just quoting Law 360.
that's because Judge Connolly has a different order that has nothing to do with litigation funding.
Well, yes.
But I'm so glad you rely on IP Law 360 instead of the people who actually.
I have nothing against you.
IP Law 360.
Let me ask you a question.
Wait a minute.
Just real quick. First of all, we are going to come to you for questions. So you can be part of the fun. So just give me a minute. We'll come to you. But Paul, you go and say what you're going to say. Then I've got a question for Courtney. But go ahead.
Okay. I just want to make one point about David versus Goliath. There was another case in Connolly's court that came to light, which was the Nimitz case. In that case, there was a third-party funder that buys some patents.
Connor's head's about to explode, just so you know.
Sets up some shell companies.
There are drinks afterwards.
There was a surgical assistant. There was a food truck owner. Set him up with these companies and these patents and had him sue another tech company.
He's a little guy.
And it all,
Food truck owner.
Is-
it all,
no
it all, it all
foreign
unraveled.
involvement.
It turns out that I think it was the surgical assistant, she didn't know what was going on. She was set up with this. The funder was going to get like 90% of the profits. The people who were set up with the shell companies assumed all liability in the case.
I mean, it sounds like every plaintiff side class action.
It came to her like having to testify, and she was freaking out. She was texting the funders and saying, I don't know what's going on. I can't do this. And they're like, well, you better get on the stand because you're signed away all liability for your failure to appear before the court. That's a case where the funders are involved with a scheme to set up people as Davids, but it's really, they're the Goliaths. They're the Goliaths in that case. And this is what happens when your fiduciary duty to maximize profits trumps duty of loyalty to
I mean, that is a problem though in all plaintiff side class actions, right? I mean, every plaintiff's law firm in America goes in, I mean, you see them on TV, right, ginning up the average person who wants to get their $50, right, so that they can get their big
Yeah, the
attorney's
problem
fees.
though is when you have a third-party funder whose sole fiduciary duty is to maximize profits, the incentives go up the wazoo to
Yeah.
do that. Because, there are a lot of lawyers who just wouldn't do that because they don't think it's ethical.
So
But once you
Courtney-
remove
So Courtney,
the
if you-
duty of
yeah.
loyalty to the client.
I mean, that
you end
case
up-
was crazy. I totally concede. I don't think it was a funder. I think it was actually plaintiff's counsel's wife. Okay, so it had no
the
funding.
correspondence is between the funders, the counsels, and the people set
I
up
think
for
they're
this.
all part of the same group, though. And there's no foreign. It's a crazy.
Somebody's
It is
getting
a crazy
divorced
set
then.
of
That's
facts. But it is. It's not a. It has nothing to do with foreign anybody. I do want to be really careful here.
Yeah.
There's two different things, and I feel like we're conflating them. There is the funder, and there are all the investors behind the funder.
Yeah.
So even in Paul's hypothetical of, and we could have a whole nother session on the control issue. I totally agree with that. It's just that's not what we're really focusing on here.
Yeah.
But the funder, the agreement is with the funder, okay?
Yes.
All of those investors in the back, they have the blind pool passive. They have, even if in your hypothetical of Cisco, which we're hearing is not the case, there were puppet strings happening, the investors don't touch those puppet strings. The investors are way in the back.
Yeah.
They get an annual update, maybe, right? So I just want us all to be really clear and not conflate
Yeah.
who these people are.
So let's talk about the investor piece, then I'll turn to the audience for questions. So would you dismiss, put aside VLSI because that wasn't your case, right? Okay,
Well,
but
no, VLSI is a fortress investment. It is not a litigation funding.
okay, fine. Okay. But Fortress, with Fortress money, they're litigating.
It's a private equity
Okay,
company.
it's private equity. Okay, got it. Okay, but Fortress, would you dismiss litigation if you were forced to disclose your LPs?
We can't first of all,
So
Fortress,
in terms of your investment agreement, you're not able to disclose your LPs.
we
right?
have
So would
confidential
you-
obligations to do
right,
it.
So would you
and
dismiss litigation?
I don't think we could not.
Okay, you'd have to, right? Okay.
I don't think
that's-
we
this is the
we don't
problem.
have a choice.
This is how we get shut down, right? Now, what happens if there were a law requiring you in federal courts to disclose foreign investors, right? You'd have to write that into your agreements.
You'd have to write it into your investment.
You'd have to write it into your investment agreements, right? Otherwise, you'd be in violation of federal law.
That's right.
Okay. So going forward, if there were a law that required you to disclose foreign investors, you just write it in your investment agreements, and everyone would know, and either you'd now. Would that shut down your pipeline of foreign investment in your litigation?
Yeah, I think it would.
And I know you probably can't, but I'll ask the question, and you can feel free to say no. Can you give us a sense of what scale that would be of your fund?
Oh, no. And I mean, I probably shouldn't anyway, but
Right.
I don't know.
You don't know, okay.
But what I would say is this, that's because we're really worried, all these disclosures, I'm really, really worried about getting it to the other side.
To
Because
the domestic side?
No,
Oh.
to the defendant, sorry, the other side of the V.
Yeah.
If you say to me, Courtney, will you share it with the judge? Absolutely. I've also had people post hypothetical, would you share it with a third-party regulatory body where it would be
Yeah.
allowed to remain confidential? And if I had confidence that would be the case, absolutely.
Interesting.
We aren't hiding anything.
Yeah.
We just don't want the other side of the V to see it and send FOIA requests to our investors.
Okay.
Or use it for strategic purposes to know the plaintiff only has 10 million, so if I drive them to spend 20, I can crush them.
Although in a regular piece of litigation, you do know that, right? Because you know who's on the other side, you have a sense of how big their war chest is. In most litigation, you would know that.
Yeah, you do know
And people
that.
do it all the time,
Yeah.
right?
My worry is more in harassing the investor.
Yeah.
Personally,
Yeah.
I worry less about the strategic import, even though I understand
Yeah.
the argument. I worry more about it on the as you said, like drying up the investor
All
pipeline.
right. I did say I would give the audience time for questions. We got about 15 minutes left, or 12 minutes left. So who's got a question? Yeah, right, please.
Quick question. Whoops.
There might be a switch there.
Quick question.
Yep.
Just curious, how much of this is just comes out in the regular discovery process?
Who the funders are, or who the people behind the funding are?
Interested parties. So like when the judge says, okay, you guys are all here, is there anybody else who's not in the room who has a financial interest in this? Like, to what extent does that just come out in regular discovery?
There was a local rule in New Jersey that disclosure of any interested party that had any financial interest in the outcome of litigation was to be disclosed. So we monitored this for a time, again, when I was at Burford.
Yeah.
And it became comical almost. There was one, I think, instance of a funder being disclosed, and every other interested party was, an insurance company, my mother who's paying my legal bills, nonsense. And frankly, if you have a lawyer who's taking the case on a contingency basis, that's an interested party. Is your line of credit with Citibank, who's going to get maybe their line paid back because you want to, it just goes on and on and on. So the disclosure bit, that doesn't really answer your question in terms of discovery. My experience is it's not discoverable.
I have one little clarification. A lot of federal courts have a Rule 7.1 disclosure requirement, and that's for purposes of conflicts. It's for the judge to make sure that he or she does not have a conflict in taking on the case. So it's not because it's relevant to a claim or defense, right? You have to identify beneficial owners. Different districts have different sort of local adjustments to that. Some of them have thresholds. So they'll say it's not everyone who's had an interest. It's anyone who has over, for example, a 20% interest. And then you have to disclose those. But you have to disclose the fund. You don't have to disclose every individual investor. And then I agree with Connor. Once it comes to discovery, when your rules of evidence require that it be relevant to a claim or defense, most courts, at least all that I know, have found that it is not relevant to a claim or defense.
And the deals are done under, the way we would do it was with a non-disclosure agreement to give protection under the attorney work product doctrine as you are preparing for trial, and all of those communications, including funding, were protected under that doctrine.
All right, other questions? Yeah, in the middle.
Yeah, interesting discussion, love the back and forth. From what I gather, there's at least one position that everyone on the panel can agree on. Some may not be happy to stop there, but at least everyone can agree on this much. Correct me if I'm wrong. Firstly, disclosure of funders' connection to countries of concern, those 4 countries. I think everyone seems to agree on that. That would be okay. And secondly, it's fine to have disclosure order for the investor and the identity as long as it can be confidential, only the judge would know it, to assuage concerns about violation of legal ethics. So could everyone on the panel be fine with just those 2 things at a bare minimum?
I worry that it's a slippery slope.
Yeah.
I worry that you start there and everyone's just gonna chip away.
But you're not a no.
Right, but if you said to me you have to do something, absolutely, because I don't think we have anything to hide, like I keep saying. So, especially disclosure if it were only to the judge, I don't personally have a problem with that.
Paul?
Well,
I'm gonna run down the panel.
I would agree with you. Let's go at least that far. I think we should go further. But of course, if you're asking me like, hey, should we go at least that far? Of course.
Dean Osenga?
I would probably be the one pulling back the hardest because it's not my livelihood, but I would say I barely would agree with you, and I would hate it a lot. But largely for what Courtney said, it's not going to stop there. The outstanding bills don't stop there, and so I don't think that the predatory infringers who are pushing the big bills are going to let it go at the 4 countries Jamil named off. So no,
No.
Yeah, and I largely agree with Courtney on this one. I think it's also worth noting that looking at it the other way, we saw tons of investment opportunity on behalf of OFAC-listed countries and individuals where we weren't going to invest in matters in those jurisdictions. We did a lot in international arbitration.
Right.
We weren't going against those tribunals and things like that. So it's kind of works itself out.
Vishal.
This whole conversation reminds me of something one of my old bosses had told me. You've got, industries that are regulated, industries that are about to be regulated.
Right.
And so, ultimately, with any new industry, like there's going to be a lot of thrash about what's the scope of disclosure, whether you should
Right.
even have disclosure, what you can do, what you can't do. And ultimately, these are questions the court's going to answer, Congress is going to answer. And so,
You're not going to take a position.
not going to take a position.
All right.
And which one more thing about
There you go.
one more thing about the
So
slippery
you
slope.
got three half-hearted yeses, a definite no, and a definite I will not tell you what I think. All right.
By the way, the thing about the slippery slope, though, which is kind of funny, you work on Capitol Hill for many years. You never pass any legislation.
No, that's right. That's the
slippery-
only argument anybody makes.
Come on,
Right, that's right.
Let's not make
I've
a law
made
against
that
murder
argument
because
all
then
the
they're going to
time.
ban
Stop
bank
it.
robbery. What? Come on. Everything should be evaluated on its own merits.
Yeah. All right. I think we have time for one more question. No, two more questions. Anybody? Oh, yeah, right here in the front, please.
You folks have been emphasizing on fiduciary duties and relationships.
Yes.
So when it comes to these smaller corporations, they obviously owe fiduciary. They have fiduciary duty towards their clients. And
Their own investors.
yes.
Yeah.
And the larger corporations, they also owe fiduciary duty towards their clients.
Sure.
Why is it that the smaller corporations have to disclose everything, not the larger corporations? Because, for example, in Morgan Stanley, there's billions of investment from all sorts of countries, and the list is so huge that I can't even name every single individual country. But why is it that all these smaller companies or corporations have to disclose each individual country?
Well, I don't think that's what's being proposed, right? Sorry. The question was, so if you have a small corporation suing a large corporation, why doesn't the large corporation have to disclose all of its investors, right? If the small player and the financial litigation has to show their investors, right? And so, at least in one case, we're talking about large litigation financiers, right? Burford and Fortress aren't small, right, by any stretch of the imagination, right? But then the question is, okay, well, but they are in some cases representing the average person, right? Some cases representing Cisco, right? It varies, right? But your concern is that it's uneven, right? And I think I don't know. What about that?
Publicly traded companies have, extensive disclosures, to the SEC and elsewhere. I think that, was it like insurance agreements, are disclosed if you're like in an auto accident or something of that nature, basically. So I think it was Federal Rules, Civil Procedure 26, something like that. And so.
So there are rules requiring disclosure.
Yeah, there are rules. And then you have extensive discovery on the defendant side. And so I think, there's disclosure at least on the defendant side, you get plenty of it. So.
Go ahead.
I was just going to say, one thing we haven't talked about today is it's a very limited basis, but we have done some defense side funding, which you have to get creative to do, but query whether you should be disclosed on the defense side of funding.
It does feel like the pressure on the plaintiff side,
Indeed.
right?
Yeah.
Because to be fair, you're bringing the suit, right?
Right.
There might be stronger arguments counseling in favor of protecting defense agreements than there would be protecting plaintiff side agreements.
Right, but I'm just in.
What's good for the goose might be good for the
Exactly,
gander. No, you're right.
Yeah.
You're right. But you can see the equities,
Of course,
right?
of
Yeah.
course.
But so Judge Connolly's order, that there are two, just so that we don't confuse them.
Yeah. Why don't you tell us about this? 'Cause we don't.
Yeah, so Judge Connolly is the lead Delaware District Court judge. He has his own two standing orders. This may be what your question's getting to. One of those is to disclose litigation funding. And I don't know if it requires disclosure of the agreement or not, but it certainly requires disclosure of who the funder is. The other is to disclose all the beneficial owners up to an individual or a corporation. And it's not plaintiffs, it's plaintiffs and defendants.
Okay.
And so it's very asymmetrical because public corporations don't need to make the disclosure, but non-corporations do. And I am not a corporate law expert, I'm a patent litigator by background. I went to a couple corporate lawyers and said, can you explain to me the difference between the vetting process for a public company for their investors in a private company. And they said, actually, from our perspective, the public company has less safeguards. And that is because you can create an entity anywhere in the world,
Yeah.
and you can buy the public securities.
Right. You can create it in Nevada and have no disclosure and buy the security.
Or China, or like anywhere. Whereas for us,
Separate problem that we should debate.
we have a third-party fund administrator. I'm going to make sure my notes are accurate because this is not my area of expertise. That perform initial and ongoing money laundering constantly, right? And then we constantly check whether they're on the OFAC list at the time of becoming an investor.
Your LPs.
All our LPs,
Yeah.
and throughout, we have to do that, right? And yet we have to disclose all of our LPs, and yet a public corporation who has a ton of owners doesn't have to disclose theirs.
You probably don't know who their owners are, to be fair.
But guess what? I don't know who some of my, I know the LLC.
You could.
We can have that conversation at dinner, but the answer is probably not. But I do think there's an asymmetry. And though Jamil, your point was it's plaintiff only, the order in Delaware is plaintiff and defendant.
Yeah.
And in fact, now you're seeing companies sue defendants, parties as defendants, and then complain to the judge that the defendant isn't making a disclosure of all their beneficial owners.
And the net result is people are avoiding filing in Judge Connolly's court.
Delaware filings are
Delaware,
yeah.
just on the off chance they get Judge Connolly. They don't,
Right,
they don't
that's
do
the
it.
wheel.
Exactly.
Yeah. Okay, last question? If not, oh, wait, at the back, we do have one last question, all the way at the back. I feel like this is Price is Right. Come on down. Come on down, man. Justin.
Tend to be on the pro side of the IP ledger when it comes to policy issues. And I just want to get a clarification. This third-party litigation disclosure issue, how long has it been around?
I've only seen it perk its head up in the last 5-10 years. I mean, how long has Burford been
But
around?
it preceded the whole China issue, correct? I just think it does a real disservice to the interests of patent owners generally when patent issues and IP issues are cynically wrapped in
the China wrapper.
It's in a China national security wrapper.
I mean, that is to be fair, right? That is true of a lot of things today, right? And it's partly because, right, China adopts other strategies that are used domestically as part of their national security strategy, right? It's not, I mean, it'd be nice to say, well, it's just people cynically doing it. The reality is China's the cynic. They're the ones taking advantage of our system and using it against us. But
They're good at it.
they're good at it, right? All right. With that, please give a hand to our panel. Thank you for being here. Thank you all for being here.